Okay, thank you everyone for joining. Just so you know, we are recording this session because we are getting absolutely inundated at the moment with inquiries all around the country. So hopefully this FAQ session or info session can be used as a little bit of a tool for those that couldn't make it today to know where we're heading and how to help, how we can help them. Just from the get-go, a couple of housekeeping things. So you've all been put on mute. So unfortunately, we're going to spend the first little while talking at you. But if you would like to engage with us, please send us a chat in the live messaging, and we will. Can't hear you. No sound. Can you hear us, Miles? Miles has been muted. Sorry. Okay, all right, everyone can hear. Great. So I'll just do a quick round of the table. Sophia's just off camera here. She's sort of moderating, helps answer some of the phones, so you probably engage with Sophia. My name's Jack. I'm director of the Red Union Group, which is sort of the umbrella organisation that looks after Nurses Professional Association of Australia, Nurses Professional Association of Queensland, Teachers Professional Association of Queensland, Teachers Professional Association of Australia, the Professional Drivers Association of Australia, the AMPS, Australian Medical Professional Society, and possibly even looking at doing a couple of other unions as well, because we're being inundated with calls from people from Victoria and from New South Wales who would like assistance and have similar workplace health and safety concerns regarding this mandatory jab. So also we have Tracy, Dr. Tracy. Tracy is a vet, doesn't like me calling her Dr. Tracy, but I will call her Dr. Tracy anyway, but knows Tracy volunteers with us, coordinating some of the medical stuff, and is totally up to engage with the science, and is coordinating our big volunteer team outside that's helping with the phones. I will apologise if you have been trying to get onto us. We've been absolutely pumped at the moment, so we will get in touch with you, but hopefully this session will explain how you can help yourselves through our website to protect your position and help join the fight. So also we've got our illustrious president, Marg Gilbert. She started off as the president of the Nurses Professional Association of Queensland and is now the national president as of this weekend, as we rolled the NPAQ into going nationally. So thanks for joining us, everyone, and thanks you guys for joining us. On the other lines, you'll see you might see Miles. He is our absolute. Oh, internet is unstable. That's probably why. Are we connected to the right internet?
Yeah.
Which one?
The normal one.
Oh, no, I'm guessing yes. That's why they can't hear us.
Should we try Nikia?
I guess so. Hopefully we don't drop out. That'd be a disaster.
This is the same one.
So that's why, because we're on the crap internet. All right, are we back? Sorry about that. We were on the wrong internet. So now we've got the fast internet. So hopefully you can all hear us. Great. Thank you. So we haven't got into anything juicy yet. It's just through the intros. But we've got Miles on the other line, who is a industrial advocate, an absolute legal genius, and knows this stuff inside out, and is helping escalate our matters, and is helping now, well, started with nurses in Queensland. Now we seem to be helping various industries all over the country. So Miles, thanks for joining us. Do you want to start from the top about, I guess, our concerns with our workplace health and safety, and where we're at and what's sort of happened in the last couple of days? I think, Sophia, you got to unmute Miles. You got to type in the search bar at the top, Miles, and Miles will probably come up. There you go. Miles, unmute.
My whole office would love being muted, so I appreciate the opportunity to be unmuted. And good afternoon, everyone, and thank you for taking the time. Appreciate you all care very much about your own safety and your own very reasoned concerns with the current health directive, if you're in Queensland, or other public health directives that have existed, and employers otherwise using the power to direct employees to get jabs. Now, we have the benefit today of two very significant developments coming out. One is that rapid testing has now, as of today, been accepted by the TGA. That is a really important development, which we'll discuss in a moment. And the second one was a very significant decision out of the full bench of the Fair Work Commission, which doesn't affect state government employees with the exception of Victoria, but it goes to where the commission is thinking. Now, two commissioners were very risk averse with relation to employers' orders and gave them a fairly wide berth, but a very, very detailed and very, very firm dissenting decision came out from Her Honour that was a very, very important read, because in essence it echoed the concerns and the approach that has been taken by your multiple unions. And I am watching the last week and a half has been an exercise in understanding communication in a very different way. In that when it started with the NPAQ, and I appreciate now a bunch more unions have got involved to assist, but Monday last week it was go away, we're not talking to you. And today I see Dr. Wakefield has sent a letter out which greatly softens and addresses some concerns and asks nurses to put through exemptions, etc. Cold reality is that a health directive does not sit on its own. The health directive must comply with other laws, and that health directive must comply with safety laws. And what the dissenting judgment from the Fair Work Commission showed was that at the moment, any forced jab could in fact interfere with Australia's obligations towards your human rights about experimental treatment. And it is an incredibly detailed and well-referenced decision that will frame it. And she puts everybody on notice, by the way. I thought I'd read you an ever so slight completion of it, which was the very last lines. Because since we've started to do this, the phone has rung suggesting that we are somehow trying to, and I quote unquote, consult so that we can kill Granny, or that Granny will die as a result of us consulting about your workplace health and safety. And despite the emotive language, I thought I might just steal from the Deputy President's own words, where she says in 3 paragraphs, all Australians should vigorously oppose the introduction of a system of medical apartheid and segregation in Australia. It is an abhorrent concept and morally and ethically wrong, and the antithesis of our democratic way of life. She went on to say, Australians should vigorously oppose the ongoing censorship of any views that question policies regarding COVID. Science is no longer science if a person is not allowed to question it. And finally, for those Australians, including those who hold or are suspected of holding so-called anti-vaccination sentiments, are entitled to the protection of our laws, including the protections afforded, in this case, under the Fair Work Act. In this regard, I could only hope the majority decision is recognised as an anomaly and not followed by others. And what that's about is that cases turn on their own facts, and normally a full bench decision would hold other single-member commissioners to it. But what she is saying is that this case has some very specific ones that might not bind other commissioners. But for the first time, a very senior member in the judiciary or quasi-judicial system has said that it's not fair to say that someone who's asking a question about their safety should be tagged as an anti-vaxxer. She specifically mentioned healthcare workers in that, referring to healthcare workers as well-educated. They work in the health industry and the care industry and have questions about how effective the vaccines are in stopping transmissions, whether they are safe during pregnancy or if they affect fertility. So for the first time, a commission has heard the very fair and reasoned arguments that a lot of you have been making, that there is a very legal reason why we're pursuing the course we are. not because of some rabid anti-movement and to quote the term anti-vax, but rather to deal head on with your safety. The law is clear, you should have been consulted with. So when the Public Health Directive was issued, it says there that it recovers the Work Health and Safety Act on there. But when you read section 51B of the Hospital Health Boards, for those that are under the Queensland nurses, if a health employment directive is inconsistent with an act or subordinate legislation, the act or subordinate legislation prevails. What that means is that just because Dr. Wakefield has issued the edict from up high doesn't mean that each business unit doesn't need to talk to you about your safety. What's been fascinating is to watch the last week and a half. What started as go away was, oh, we'll get back to you. Then we'll go and then it's gone to the department's office. And then we've got this edict from, again, a clarifying statement from Dr. Wakefield today. And it then goes so far as in some cases to suggest to threaten jobs or to threaten punishment. Now, he set the timeline, not us. On the 11th, he sent the directive out using the powers given to him under the Hospital Health Boards Act. He set the deadline, not us. Now, I can only commend your union for resourcing and dropping everything to deal with these arbitrary deadlines. And there are similar deadlines in other states for those that are not covered by that directive. That magically the end of the month also happens to be a risk day, and we don't agree with that. So, as many of you have already seen, we've sent letter after letter. Some of you have got the first letter and you ignored, second letter ignored, and today the third letter was ignored, and some of it, and there is more to come. I'm very proud to say that Mark Gilbert yesterday, as the president, wrote to the Dr. Wakefield to ask him for his reasons for decision. That is a precursor to and a requirement under the Judicial Review Act for him to explain himself. And subject to what comes back, Mark, as your president, and your union is considering all options, including attending the Supreme Court and asking the Supreme Court to look at it. And we call upon Dr. Wakefield to hurry up and get that document to Marg so that she can understand the reasoning, to understand how he has waived your human rights, how he's waived your human rights to experimental treatment, and how he's waived your human rights to be consulted with about your safety. We're most curious as to how he's considered rapid testing in the workplace, which would actually identify a COVID positive person and engineer it out, versus experimental vaccines, which are being used as an edict. It's not about being anti-vaxxer, it's about being genuinely concerned. There are some reports that are suggesting that people that are built like me get a further enlarged heart. There are others that are questioning the fertility. There are others still that are questioning other cardiothoracic issues, all of which are fair and reasonable questions. And to have a question where you'll be not paid or you face discipline is entirely improper without a consultation process. And in talking with Marg and Tracy and Jack, we don't doubt that had you been consulted with and had you had an opportunity to understand, you might be less concerned, that you might have joined it. And indeed, the Deputy President of the Commission speaks to that point and saying that when you move to mandate rather than talking to people, and I'm summarising, that you are bound to cause problems. And they should have done this first, but again, they've set the deadline. So it's a fabulous arrangement for them, isn't it? They set the finish date, ask you to scramble and threaten you with either your job or discipline when they control it. Well, that might be something the Supreme Court needs to look at. And there is already one application, as we understand it, before the Supreme Court to have the health directive set aside. And it is with some degree of pride that I say that between Jack and the various teams, we've also been given the instructions to brief both senior and junior counsel to review Dr. Wakefield's reasons for decision, to consider whether or not it is appropriate to also seek for that directive to be set aside. But so far, it looks like that might be the road forward, but we've of course got to make sure that we're protecting all of your interests and being calm and rational, and we won't go in boots at all. And we do hope that Dr. Wakefield can get us that reasoning, as he was meant to have done. That decision should have already been done, and that document was written prior, or should have been written prior to the health directive being issued. So it should be a no-brainer for him to be able to get that to Marg in the next day or so. So in short,
Do your wrap up, Miles.
so in short, that's the very long-winded opening. There are many questions I'm sure you've got with relation to exemptions and your personal circumstances, and I just wanted to frame it in the context of both international law, state law, safety law, all of which are relevant, and all of which are the rabbit holes that your union is looking at on your behalf.
So I will thank you very much, Miles. I'll just break from the law very quickly. I'll just cover who can join NPAA, Nurses Professional Association Australia. That's open to all. Nurses and operational staff can join as affiliates all around the country, and we will be taking exception to any cutting of corners when it comes to workplace health and safety that's happened anywhere in Australia in any industry that we're covering at the moment. And it seems like it is a pervasive issue, and it's happening across all states in a number of industries. So there does appear to be something that we can do to help protect your rights in that regard. We also have the Australian Medical Professional Society, which is a union run by doctors for everyone. Doctors went out of their way to say that they wanted to be able to cover wardies and anyone else in the health space across the country. And you can join that as an affiliate. You get all the exact same protections. You just won't be able to vote on the executive. We also have the Drivers Association, Professional Drivers Association. I note that the vaccines were made mandatory in New South Wales for drivers recently, as recently as today, I believe. So there's a lot on. We also have the Teachers Professional Association of Australia. It appears that the risk assessments haven't been done at a school level at schools in New South Wales where they've mandated the jab. So I would recommend that you join the TPAA, and we can give you some advice around that as well. Now, from the top, what do we ask that you do? The first step is go to our website, and we have a notice at the top that says, concerns regarding workplace health and safety. Stage one is to request a risk assessment. Now, at all times, we're totally acting in good faith, and we are happy to engage with our employer, obviously. So the first step is to email your line manager and ask for a risk assessment. Now, I do stress that if you're a Queensland Health worker tuning on now, or a New South Wales police officer tuning on now, the deadline is very close. So I would recommend you do that as soon as possible. Stage two is when they have either ignored you, and by ignore, that's probably going to be within sort of like a day now. If they've ignored you, they've responded with an inadequate risk assessment, and we have not seen an adequate risk assessment yet. So an adequate risk assessment, they must have risk assessed the impact of COVID-19 on employees at a PCBU level. So basically at a ward level, at a school level, at a very granular level, and of all staff. And then, have in that risk assessment, it should mention the word vaccine, where that risk assess the vaccines and the impact of vaccines. So if you don't get that, then elevate to stage two, where you'll have to become a member of NPAA, TPAA, AMPS, your respective union. And then once you have become a member, you go in, and on your members dashboard, there is a COVID concern form that we ask you to fill out. Once you fill that out, you'll enter into our system, into our CRM, and then that will elevate your case. You'll be given then another letter, automated email to you, which you need to fill out. That will come to us, and we will forward that on your behalf, which will then appoint us to be able to act on your behalf in relation to this. There's a couple of other stages we've escalated from there. If people are ignoring you, or if they're trying to send you off to talk to the Office of Industrial Relations or someone else, complaints hotline, instead of engaging with it themselves, a recommendation to you, and this is very important, is that you email your line manager and your line manager's line manager, and then also CC in that complaints line or wherever they've asked you to go, and say that you're following the proper process. You understand that you need to escalate this matter operationally through the right channels, and that's what you are doing. You're going through the right channels, so it's going to your boss's boss. Then if it needs to go to your boss's boss's boss, do that as well, and we will record that all the way from our end. So that will help you go through all those stages. And again, for our interstate friends as well, if you do that within the NPAA site or the TPAA site or the Australian Medical Professionals Society site, we'll be able to help you there. Back to our Queensland friends though, Miles, there's a few questions coming in about the letter that came from the DG today, and people are concerned that it looks like he will be trying to sack people, is what they are saying on the chat. So would you like to address the DG's letter today?
Yeah, and bear in mind there are two parts of it right now. I am pleased to say, first of all, that your union has already responded, as have many individual members, to that document to put the Director General on notice. We say if you're exercising your workplace rights to be consulted with, and that your employer knows this and tries to take any steps to reduce your job security or to threaten to punish you, it could be a breach of your general protections. Now, one of the questions asked there was, does that give rise to an injunction? And it very well may. But I don't, I think we need to deal with things on a calm and rational basis, in that I think that we go back and we ask it. Now, it's up to your employer to try and take the disciplinary steps. And if your employer was to try and fire you or to threaten you with public service discipline when you are going through a work health and safety process that with non-compliance with it can bring serious offences, that would be a very, very brave employer. So we are ready, willing and able to work. And as you've all rightfully noted, your employer started to flick past those, but they're not anymore, they're now engaging. And so it is their deadline. So yes, that letter does look scary when you first read it. It also invites exemptions and has softened its position significantly. So while by no means is it a letter that we think is appropriate, because it does still threaten, it is reducing the, if you like, the prescriptive nature and the force of the directive by seeking exemptions and giving some wiggle room. And there'll be more of that to come. But if you have exercised those rights, those stage 1, stage 2 and stage 3 consultation processes, and you've done so in good faith, if your employer thinks that they're going to be able to discipline you, well, then you will have the full weight of the union, and including both junior and senior specialist employment, safety and human rights counsel on your side as part of your membership. So it's one thing to write a letter and an all-persons email with the bullish subject of must read. How about must consult? Because that's what I see in that letter, rather than must read. If we're doing must there, Dr. Wakefield, how about we must consult?
Wonderful. Now, Miles, if I'm a casual, should I be sending off a request for a risk assessment, or should I be flying under the radar? There's two issues now, and I have to adapt a position that I gave earlier in other ones. So if you've been in a different video conference, you're going to hear something slightly different. The directive, as it relates to your private information, may in fact be unlawful, and we are finalising a position on that. So that position will be finalised by tomorrow. So before there is a requirement to upload any material. So first of all, it is the advice that until you hear from us, do not upload anything. It's not due till the 30th anyway, but do not release your private information at this point until you get a considered position from your union or unions. Secondly, on that one is that they have made it clear that if you don't upload that material, then they are going to take you off your roster. So I can't tell you how to act in a good faith way, other than to say, if you are genuinely concerned about the risk assessments and whether you be casual or not, if you are not comfortable that your employer has consulted with you, then of course my strong advice, and the strong advice of the team here, is that you absolutely do commence that risk assessment question process. If you are doing it in bad faith, then you ought not to do it. Excellent. I'll just deviate from the questions for 1 second. I just thought people may be interested in some surveys that we've conducted. There was a survey conducted in WA that this is a WA nurses union, nothing to do with us. That came back, 30% of nurses would rather leave the profession than get the jab. Interesting. We did a survey at the beginning of the pandemic. 75% of respondents said that the jab should not be mandatory. 80% said that the jab should not impact on your employment. More recently, we've done another survey with, I think it's up to 2,200 nurses have completed that survey. I think it's about 56% of those, or 1,400 nurses, had not taken the jab yet. Now, it may be that data is skewed and you can't extrapolate that, but that alone, 1,400 nurses who haven't been jabbed, is enough for concern, I would think, for health executive in Queensland Health to see how are they going to grapple with that issue. They also then, in that survey, 600 out of the 2,200 said that they were coerced into getting the jab. So I guess that's where our mandate is coming from, to examine this issue. Separately, I was contacted again by a journalist today. There was some statistics released from Queensland Health to journalists saying that 10,000 Queensland health workers had not uploaded or provided their vaccination status, and Queensland Health suspect there were 10,000 nurses who had not been jabbed yet. So I can tell you right now, if 10,000 nurses leave the system, a system which employs probably around 40,000 nurses, the system will absolutely collapse. I had another journalist come down to me today saying, wow, geez, isn't it interesting? You know, nurses are so under the pump at the moment. You know, they're called in for these double shifts all the time. I said, yes. And they said, oh, what are they going to do when all these nurses leave the system? Yes, all questions that are very valid questions, and questions that I think the Director General should be answering himself.
Particularly as all of you want to care for your patients. And the starting point of this is, this, as I've said in other ones, is like a reverse strike where you're ready, willing and able to work, and your boss is shutting you out simply because they've drawn an arbitrary line in the sand that happens to coincide with the end of the month. And to hear, not like Jack saying, the system might be put under pressure. 10,000 good, honest, caring nurses not able to care for patients during a pandemic because a bureaucrat at the top of the tree, an unelected official, puts a line in the sand without so much as talking to you.
Miles, what happens come the 1st? Deadline's passed, what happens?
Well, I assume that some leadership people from Queensland Health or other employers may be on this call, so let's just call it for what it is. It's up to you if you want to take that road. When good people have sought to consult with you about safety, when you tried to bypass their safety rights, well, then you should expect a fight, and you're going to get one. The first thing we're going to hold you to do is actually consult on the safety issues, because as the Deputy President made clear in her dissenting judgment today in the Fair Work Commission, good people who are good, well-informed have questions and just don't like being forced when they may need some more time. So the first thing is, it's up to your boss to stand you down, it's up to your boss to punish, and we will deal headlong with every single one of those events. The most important thing is we want to know about your safety. We want to consult with your safety. Do that, and you might have a bunch of nurses getting a jab. Don't do that, and then you're going to get a jab from us. That's a bad joke for the day, sorry.
So I guess to drill down on that point further, because that is what happens on October 1st. We're not taking strike action. Do nurses turn up to work, or are they not turning up to work? Does that depend on what their specific line manager has told them to do? Do we need to follow that? This
is a question that's across the board. If you've been given a direction to have something done by a certain date and then you were to turn up to your work site, you may face disciplinary action. It's very important. We will clarify on your behalf what that means, but the current component is do not turn up to work, do not turn up to the physical site. So you don't want some mischievous boss turning your good faith desire to turn up and to protect a patient or to protect a student or to teach or whatever it is that you do, and then have them say you've broken a lawful order of your employer to be restrained from the site. Your boss does control the private property. So if you have been told to stay away, let us clarify what that means. Is it totally stay away from a certain area? And that will require a case-by-case response, but you would be at risk if you were to be told to stay away and then turn up. You may give your boss a bullet that they didn't otherwise have to discipline you, and you should be really reasoned about it. remember, it's not us that wrote this rule. It's not us that drew the line in the sand. It's not us that did it in the absence of consultation. So don't give them a trigger.
So then there's another question. If a boss is asking individual staff members, will they be vaccinated? So because they're doing their roster and they need to plan for the roster, moving forward past October 1st, what is the response there?
Will you consult with me? It's a real simple one, right? I don't know. I'm still waiting because the law requires that you consulted with me on that vaccination process. I very well may. How about you spend the time to consult with me as the work health and safety laws required you to do?
Wonderful.
You don't use that high-pitched voice though.
in New South Wales, there's a deadline coming up as well. Do these same risk assessment laws, work health and safety laws apply? Are they applicable? And do they just follow the same process in New South Wales?
Any work site is still responsible for its work health and safety. The Fair Work Commission dissent decision today also made it clear that the directive still has to be consistent with the minimum intervention available. So depending upon your job, just because there is a direction doesn't make it lawful, but of course, if it's been gazetted by a minister, its approach needs to be considered on its merits. There is a separate judicial review that has been filed in New South Wales, and so those things are all relevant. At the very least, if you're in New South Wales, the consultation should commence so that we can understand the safety environment in the event that the Minister's Health Directive gets set aside by the New South Wales Supreme Court. So absolutely. Sorry for the longer answer, but definitely.
What happens if I'm put on unpaid leave?
There's a couple of questions about leave, and I'll allow me to address it. It's not you that's withdrawing your labour if you're ready, willing and able to work. So it's your boss's one. I appreciate, though, that for some of you, playing this is a very tricky game because you've got families, you've got mortgages, and your boss is threatening to not pay you. The first position is that we need to say that we're ready, willing and able, and your boss cannot just not pay you. Obviously, that's a different rule for permanent and versus casual, and it will only deal with your ordinary hours. So your boss has promised you full-time hours and a guaranteed minimum hours. If they lock you out of the worksite for what we say could be potentially for a premature or unlawful reason, then they ought to be paying at the very least your ordinary hours and may, depending upon it, have to pay the whole amount. For casuals, if you've exercised your right and they are punishing you or taking adverse action against you in Queensland or the Commonwealth, that could be relevant. And there are similar but not the same laws in New South Wales with relation to exercising safety rights, but they are distinct from here.
In relation to exemptions, should people be applying for exemptions if they believe they have a genuine exemption?
If you are of a genuine exemption, you absolutely should be applying. In the case of the Queensland Directive, Dr. Wakefield has made that clear that they will meaningfully engage in it. If your religious exemption is because you're part of the United Pastafarian Society, then you probably shouldn't seek that exemption because you may end up having your employer take a view that you are not acting in good faith. So if you have a genuine religious belief and your pastor, your rabbi, your mufti, or your priest genuinely supports it, then you ought to do it. But if it is not a doctrine and part of the tenets of your religion, then your employer may challenge that and then question your motives more broadly. So if you are of faith and you do connect to that religion and your religion has a view on this, then absolutely. But be careful, you don't want to be massaging what are not doctrines or tenets of your religion to try and deal with this. Now, bear in mind, there has been a distinct view between, say, for example, the Catholic Church in Tasmania's archdiocese versus others. So you do need to talk to your pastor or your priest and that your church leader of your local flock, for want of a language, that's the test.
Wonderful. What is classified as an appropriate exemption when it comes to health reasons? I think that differs depending on whether it's an aged care public health order, say up in Queensland, or whether it's a private enterprise and what they have directed employees to do, and again, whether it's Queensland Health.
It is, so the hardest version is contraindication. It has a very narrow definition. In essence, it's anaphylaxis, broadly anaphylaxis, underlying conditions such as previous cancer treatment. It's a very, very small test. At risk of other impacts as a result of the jab is not necessarily a contraindication. And then there are broader exemptions such as allergic reactions and others. And so each state has a different arrangement depending on it, but you should talk to your doctor. I can tell you though, your GPs, if they're giving you an exemption, they believe it, because our experience is that GPs are being very, very cautious in issuing them. And so if you are getting an exemption, then grab it with both hands, but don't be growling at your GP if not, because it's a very, very tight test and they're under significant focus from the regulator as to how they conduct themselves. And so your doctor is likely to be the moderator.
Well, and that's a good point, Miles. I was about to say one of the reasons why the Australian Medical Professionals Society was started up was because these doctors were sick of being pushed by bureaucrats, by the government, telling them what they can and can't prescribe. And they even went so far as to write to doctors in Australia, threatening their registration if they were to say anything negative about vaccination and other things. So they have the fear of God put into them. So they, you will be experiencing very cautious doctors in this space. Into probably by APRA if they are writing exemptions. So yeah, it's probably can't get too angry at the GPs on that front.
And if for example, they say something like so-and-so says they have an allergic reaction, for example, as opposed to does have, that's the kind of thing that is not necessarily a medical certificate. So you should get advice from your union or from the legal reps of your unions before giving that to your employer, because it might look like it's giving you cover, but it doesn't.
Specific question regarding nurses who are pregnant, who have concerns and they aren't being engaged with in terms of workplace health and safety. Some nurses are being told that they won't be given maternity leave, or they won't have their maternity leave paid unless they get the jab first. Others are being instructed to go on maternity leave early. How do we make sense of that?
Look, if you're, I've heard this case a number of times with relation to, a week or two to go, you must get your jab before you do it. Just call your union straight away, and a very robust approach will be made to any employer that's misusing that narrow window of time. Those that are close, and I'm sorry for as a bloke in the room, but to the ladies, with the legal language, that is your date of confinement. So if you're within say 2 weeks or a month, and it might be, and you're 6 weeks away, you may choose to go on maternity leave earlier. Again, we're happy to advise you and on a case by case, but that actually may be a very clean way, rather than locking horns with your employer when there are so many questions around the fertility issues, that for the sake of 6 weeks of an early leave, maybe we deal with that direction after baby's born, and you can get on with your life. And I'm just being pragmatic with that answer, but if it pushes you into financial hardship, again, give the member support line a call. And if it needs to, then one of the legal team members will get on your case. On their case, I should say, not your case.
The nursing students. So there's a couple of different issues here. One is nursing students who haven't been double vaxxed have been told that they can't go on placement. I believe now, even today, I may be wrong on this, so don't hold it to me, but I've seen some queries being raised. Nurses even who are double vaxxed are not allowed to go on placement because they're not considered essential, and they are basically being turned away by the hospitals. Is there any recourse there for the university students? Is it something that we will look at examining after these imminent deadlines?
So students are still workers for the purpose of the Work Health and Safety Act. So are volunteers. So the same rules apply. The university's hospital is required to consult with workers. Obviously, if your studies are impacted by that, it may be a different cause of action. I'm a specialist in, as you've heard from Jack, in industrial relations and lay advocacy. If you've got those ones, it might actually come across into needing a civil litigator, and we can refer you on, or one of our team can assist, but it's outside of the specifics. But the most important thing is, again, consult with relation to your work health and safety, you are a worker under the Work Health and Safety Act.
A number of people have been contacting us saying that they've been invited to meet with their line manager and HR rep, saying how they're going to deal with, you as a worker moving forward past the mandate. If you're not willing to get vaccinated, I think they're putting words in people's mouths saying.
It's a very tricky little correspondence. We've seen those. Now, first of all, do not accept the thesis that they're putting in that you're being either vaccine hesitant, vaccine resistant, or won't get vaccinated. We need to snap back on that, and there's a whole team, and yes, there's a bit of a queue at the moment, but we must disabuse them of that notion first and foremost as quickly as possible right now, and so please let us know. Secondly, I don't know how we can meet and talk about the jab when we're waiting to be consulted about the jab in good faith, unless they've got the data. That's what got us in this mess. So the first thing is knock that nonsense back, that we are, and as you've seen, repeat, we are ready, willing, and able to work, and we are not refusing the jab. We want more information. We want the risk assessments so that we can be informed, because we haven't seen any yet, and we've seen a couple, and they're not risk assessments, they're dodgy. Risk assessments follow an Australian standard. Banks use risk assessments to consider how they're going to lend you money. It's the same rules, right? So it's about rationally assessing risk. That risk can be about dollars, it can be about safety, it can be even about branding, right? It is a formula and a scientific methodology to rationally assess risk. So all we want them to do is provide a scientific methodology where they have rationally assessed risk in accordance with the Australian standard.
Just a question here from Ray. I can answer that one. Paramedic in Tassie, will these first and second steps on your website apply in Tassie? More, yep, absolutely. So yes, request the risk assessment. I'm not familiar whether Tasmania have done their risk assessments or not yet. It appears though that this is a recurring theme across most industries, most states, because it's been a bit of a top-down approach, come very quickly from governments. So, and they haven't followed their legislative steps that they would certainly expect other businesses to comply with, but obviously aren't expecting themselves to comply with, but I don't think it works that way. So yes, it certainly would. You can go to our website, do the first couple of steps, and we will engage with whatever response your line manager in Tasmania responds with, and that will dictate what our stage 3, 4, 5, if that becomes necessary, how it would escalate.
And again, if you've got someone and the risk assessments are good, then let's have a chat about that. It might be that it actually answers your own questions.
Someone here asked another question. What if your line manager doesn't understand what a risk assessment is?
Well, I think we found about 1,000 of those so far. So what about we change that from what if to when your line manager communicates they don't know? Well, they're meant to, because they're meant to also have been consulted with. There are work health and safety committees that are meant to have done it. The law requires, and the grievance procedure requires, that we deal with it at a local level. So if they can't, then it should be escalated up. So, but it's to say that they don't have to give it to them, that's nonsense. Of course they do. The same as you get material safety data sheets. What your bosses are doing, saying, "Oh, I don't. What's a risk assessment?" Well, given we're all meant to have been consulted, we should all know, right?
Yep. There's a few technical questions about whether it should be step 3, third step, what to do. A lot of this is coming up to the deadline, so please try and use, I guess, a degree of common sense if it isn't making sense with the deadlines that are provided in the letters, and they're going to go beyond the 30th. Just to adapt those accordingly. But I'd be doing the state if I was in the position now and I'm just coming on board, wondering, oh my gosh, what can I do? So it's the deadline is almost upon us. I'd be setting a request for a risk assessment in tonight. I'd be going onto our website tonight, looking that up, grabbing it, sending that off to my line manager. Stage 2, I'd be getting ready preemptively, and I'd fill in a form going through, becoming a member of NPAA, TPA or AMPS, going through to the dashboard, filling in the COVID jab form that's on the member dashboard. Again, these steps are outlined from the homepage. You can see workplace health and safety concerns. That will take you through stages 1, 2, 3. That will direct you to the dashboard and have the correct link. I would then get that and I'd send that off probably tomorrow morning if they haven't engaged with it tonight, and get them on that process of, you know, I'm taking this seriously. I want to be consulted with immediately. It's not happening. Get that ball rolling as soon as possible.
Now, Jack, may I answer, because there's a question that a number of us, but I see Mitsu has asked a question at 5:28 with relation to that threat, where it says after 31 October without an approved exemption. Now, I want to go through a couple of points about that because it's a fabulous softening the position, and the language is not saying that you will be. What it says is, whilst these arrangements will continue to apply whilst individual case management is undertaken with supervisors and managers. In essence, that's a month, right? That's a big win. And that win has come from those thousands of letters that have come out of your unions, from you with the support of your union. But it then goes on to say, staff that remain unvaccinated after 31 October without an approved exemption will be considered as failing to comply with the directive and may be subject to Public Service Directive 1420 discipline and the HR E10. Well, E10, number 1, requires first and foremost to assess management action. And number 2, you must be provided natural justice. Number 2, E10 enlivens both the Work Health and Safety Act and your Human Rights and the Industrial Relations Act, all which are around exercising workplace rights. So, and the word may is used very deliberately. May. Of course, may. You know, I may wear a blue shirt tomorrow, but I might not must. So just be careful, right? That there's what that's done is go, you've got us. We didn't think this through enough. And so we've now given ourselves an entire new month. And the people sitting in that ugly burnt orange room behind you have done a fabulous job in achieving that extra month for that individual. And the language is very clear. These arrangements will be undertaken while individual case management occurs. It's something that you should all be incredibly proud of that you participated in, because then now they are slowing things down and wanting to talk to you, and that's all we've ever asked. A full month, right? So take a bow. It's actually a really big. So Mitsu, I understand that it looks like one thing. It's actually entirely another. I had a very senior lawyer ring me today going, oh my God, I can't effing believe it that we did it. And of course, lawyers can't swear, so he definitely didn't use that last word. And so be very, very comfortable that they're finally listening, right? It's the 31st of October, not the 30th of September. Sorry for interrupting, Jack. I just thought that was a really big point to make.
Right, so let's put another one here. I have had 3 risk assessment request emails ignored.
Yep.
Forwarding to nursing director. What do I do?
Well, that just means that the boss now knows, right? There's nowhere to move, and no doubt that individual management action over the next month will be very, very helpful, right? So the more they're bumping it up the food chain, the more it helps. Now, you are doing the right thing. Many would say that you only needed to ask once, but you haven't asked just once, you've asked twice, you've asked a third time, and some of you may even find it in you to help a fourth time, ask them a fourth time. I've certainly seen responses going, thank you for your additional request. As you know, I've already sent this off to the Department of Health. Well, you are responding to their time frame, theirs, not yours. And so if they can't respond to you in that time frame, well, I expect they might be not so forthright with any directions to lock you out of the operation.
That's a good point, Miles. There's another one here. If I'm only sending the risk assessment tonight, what date do I put on when do I want the response by? I guess it's important to note in that request saying, I'm trying to comply with your hurried mandate deadline. So it's probably fair for people to put in an email that they expect a response, within 12 hours. The part one, we obviously have to give you individual advice, but
at 12:01 a.m. on Friday, October 1. If you do it to the workplace, as well as inform your supervisor in writing, you must wear a surgical mask, and you must have also applied for an exemption. Now, we don't accept that that's the only musts that are there, but if you do have an exemption, that's the important part. We will deal with the other issues on a case-by-case basis as part of that individual management action that we have alerted to.
Wonderful. Okay, well, we might try and keep it relatively short at the moment because there are a number of other video calls. We are approaching 6 p.m. So there is another Zoom call, I believe, tomorrow morning.
Yep, 7:45.
7:45. We will be recovering a lot of the same ground. But there will be options for questions at the end again. And there is also another Zoom call tomorrow evening, I believe, as well. So
5 o'clock, yeah.
at 5 o'clock. So if we haven't got to your question today, I apologise, but we will be on tomorrow, and we will be taking a scrape of this chat here. So if there are some questions that are reoccurring and we haven't got to it, then we will grab it and address it tomorrow in the morning.
Hey Jack, can I throw 2 quick ones at though? Just sorry, I know that we got time and there's lots there. Someone's asked if if a lawyer, if there are other lawyers done it, right? You talk to your lawyer. If you can appoint somebody else to represent you and to act on your behalf, so if they're giving them a run around, it's the same as them giving you a run around, but talk to your own lawyer about that. We aren't here to replace the legal advice of somebody else. So please, if you're represented by somebody else, you should be taking that advice from them. And we definitely don't want to jump on top of any other representation, right? So that's a really important one to make. And if you're being forced on leave, it's critically important that you contact the member support line, because you're already willing and able to work and care for your patients or care for your students. So if you're being forced on other leave, long service, sick leave, or whatever, then it's important to know. And the final question is, I wouldn't get too carried away with the Australian Constitution. The movie Castle was a fictional movie. We need to deal with this with real law and it's state law and it's health law. And we should focus on the stuff that we can win, and as opposed to going off to the High Court, because it's not how this is going to be done. It's going to be done at a ground level. Sorry for those. I just want to get those out of the way.
Yeah. All right. Okay. Yes. Thank you. I'm a neurologist. I have a neurologist. Okay. Yes. If people do have individual queries, I apologise. We are getting absolutely slammed at the moment. We've put on a couple of extra staff members, plus we have 7 volunteers in here today, all volunteer nurses manning phones, trying to get through queries. I think we have something like 1,000 unanswered queries at the moment in the inbox. I can only apologise. We are really trying to get people onboarded, but even onboarding people at the moment is adding strain because we have to train them. So we weren't expecting this to be such a big issue, but we're trying our best to help everyone. So please bear with us. But the intention behind recording this was people don't necessarily need to speak to us in order for them to become a member, to onboard themselves, to do that first step, to then do the second step and the third step. And essentially we can protect you without you having to speak to us. But we are trying our best to do the hand holding as well and to contact everyone. So, and I see a couple of people here saying they're happy to volunteer. Please reach out and contact our hotline tomorrow. Otherwise, our office is 41 Campbell Street. Just let us know that you're coming, and we'll have a computer set up for you. But thank you, everyone, so much for coming tonight, and we will try our best to get Queensland Health to come to the party to this. I think we're having some really exciting small victories along the way, and this is changing so rapidly all the time. So no doubt tomorrow afternoon's meeting will be totally different, as the sands may have shifted again from this evening. So thank you very much, everyone. Oh, and I must say, there is a lot. We have had some pushback, funnily enough, from the Queensland Nurses Union not allowing people to resign. So they must be worried about the. I think there's probably been close to 800 or 1,000 nurses that have come across in the past couple of weeks. So what is our union called? Union is called Nurses Professional Association of Australia, NPAA. Sorry, I must say, if you want to, so if you just go to redunion.com.au, one website, www.redunion.com.au, it's got a list of all the relevant unions there where you can join the most applicable one. Yes, you can join if you're an admin. Yes, you can join if you're a wardie. You can either join the Australian Medical Professional Society, or you can join some of the nurses ones or a driver's one, depending on what's applicable to you. But thank you all for tuning in, and we will no doubt be in touch shortly.
And one last, sorry, Jack, one final one. Those I see aren't coping. Your employer does have EAP programs, and I appreciate this is a tough time. There's a lot of misuse of power from people. So most big employers do have an employee assistance program. If you are struggling, please do take advantage of it or get support through other places, because it is important that you take care of yourselves in this difficult time.
Sorry, Rachel, it's www.redunion.com.au, and you can find a union applicable to you. There's more information on each of those respective union websites about who can join, and almost anyone can join as an affiliate. Just means you won't get voting rights, but you will get the protection. So thanks very much for you joining us, Miles. I really appreciate your time.
And I'll see you for my sweatshop at 7:30 tomorrow morning. Is that right? Bring coffee.
That's right. Wonderful. Thank you.